Hello, this is Greg Maxwell with Amicus Settlement Planners. Today we're going to talk a little bit about our unique settlement planning assessment, we call it. To give you a little background about what this is, our firm, as you know, does lots of settlement planning with personal injury firms. We do a lot of government benefits, education, and we found that we were receiving calls from clients all over the country that were receiving or had received already mass tort settlements or other single event settlements who were on government benefits like Medicaid and SSI that they were worried about losing. And they would call us and say, hey, look, I just got a check for $16,000 and I'm on Medicaid. Is this a problem? And so then we'd have to kind of backtrack and say, well, yeah, it is a problem. Your attorney should have talked to you about this. And then we kind of had to work backwards to help them not lose their benefits. And so we felt like there had to be a better way to help attorneys and their staff screen and educate clients before those checks went out, so that clients weren't losing their benefits and attorneys weren't getting themselves in hot water with their clients because their clients were losing benefits. So this is what we've come up with. We call it the settlement planning assessment. First of all, here's the problem. As you well know, about 40% of personal injury clients receive some kind of needs-based government benefit, whether that's Medicaid or SSI or Section 8 housing. 40% is what we've found and what the research suggests. So without proper planning, receiving a settlement of really any amount, and that's really any amount over $2,000, but it could even be less than that because a client can't have more than $2,000 in their name and still be eligible for Medicaid or SSI. So a settlement of really any amount could potentially jeopardize or eliminate a client's benefits, like Medicaid and SSI benefits, after settlement. And that is a problem. As you know, clients are very emotionally tied to those benefits and they don't like losing them. Law firms also need to understand that they have a potential liability here, and they have a duty to inform and educate your clients about how a settlement will impact their government benefits after they receive their settlement funds. And a lot of clients are just receiving settlement funds without any advice or any referrals to other professionals to help them understand what their options are and to receive education. So there is some liability here for you and your firm. So failing to provide this education could result in, at a minimum, unhappy clients, and that's not what you want. So the solution that we've come up with is what we call our settlement planning assessment. So the first thing it does is it screens clients for government benefits, their government benefits and the benefits of those that may be in their household. It then educates them on their options to preserve those benefits. And then if they do need something like a special needs trust or an ABLE account, we can then help them, walk them through the process to establish a trust or an ABLE account, or help them spend it down, or whatever it is they decide to do. We can give them the education and help them do that. So after a client completes the assessment, it's an online assessment, it takes them about 3 or 4 minutes, our law firm then prepares an information letter that summarizes the client's specific situation based on their answers and gives specific advice about what they need to do to maintain their government benefits. So that letter is then emailed in PDF format to both your client and to you and your firm. And then the clients are just charged a flat fee at settlement to complete this process. It's billable as a case cost. It's not an expense that your firm needs to front. It doesn't come out of your fee. It's a billable as a case cost at the time of settlement. So just quickly, the benefits to your client. Number one, your client's going to be educated. They're going to have peace of mind knowing that they understand what their options are. They're going to have a plan in place that they choose to keep their benefits. And then they're going to have the peace of mind of knowing, okay, I can receive this settlement and I'm not going to lose my Medicaid or SSI. The benefits to you and your firm, number one, you're going to have some liability protection. There's going to be an outside third-party law firm, us, that's giving your client this education and removing that burden from your firm and protecting you from that liability. So now you and your staff and your paralegals don't have to wade through each client's situation and try to figure out if they need further planning or not, and it removes that burden. Your clients are much more satisfied if they can come to the end of a settlement knowing that you've done a good job for them, and not only that, but you've referred them to a partner who's helped them understand how their settlement is going to affect their government benefits. So we found that clients are much more satisfied with you and your firm by going through this process. And again, another benefit to your firm is there's no cost to your firm to do this. It's just a flat fee that's billed as a case cost, and it comes out of the client's funds. So that's a very brief overview. Feel free to give us a call. We can create a unique link, a URL for your law firm that you would send out to your clients as they settle cases, and we can talk to you more about how that process works and help implement it in your firm, and we'd love to chat with you about it. So feel free to give us a call or shoot us an email.